A very good evening to all of you. Hello and welcome, guys. My name is KP Singh, and I welcome one and all to the 24th episode of Weekly Law Scoop. We are resuming Weekly Law Scoop after a very long break of like 45 plus days. So I welcome one and all. Can someone please confirm if the audio is fine and all of you can see the presentation? Welcome Arya Bharti, welcome Prachi, welcome Shraddha. Hello Sambhav. Chale, good to read these names again. Okay, thank you Ira, thank you Prachi, welcome Dheeraj. Okay guys, so let me start by explaining the format. In Weekly Law Scope, we cover important legal news item from past few weeks. Because we are trying to cover up for last couple of weeks that we didn't conduct Weekly Law Scope, some of these news item might not be from this current week, might be from let's say last to last week or might be 2 weeks back. In order to have best experience of this stream, please make sure that you are using your desktop or laptop in full screen mode and click on the settings icon and click on the best quality available. 720p would be best. Chale guys, let's start. The first news item that I want to discuss today is regarding government's decision to raise legal age of marriage for women. The cabinet cleared the proposal to raise legal age of marriage for women from 18 to 21 years. In India, law prescribes a minimum age of marriage for men as well as women. Essentially, it was done to outlaw child marriages. So because we couldn't straight away say that no child marriage shall be permitted, we started gradually increasing the minimum age, legal age of getting married. Personal laws of various religions which deal with personal matters like marriages, divorces, adoption, succession still have their own standards, often reflecting their own customs. For example, for Hindus, the Hindu Marriage Act of 1955 sets 18 years as the minimum age for women and 21 as minimum age for men. The Special Marriage Act of 1954 as well as Prohibition of Child Marriage Act of 2006 also prescribe 18 and 21 as the minimum age of consent to get married. Now, this brings us to the question that why did government decide to re-examine the age of marriage? Well, there were many reasons. The most prominent or the important one is gender neutrality. Isn't it unfair that for every other thing we allow men and women to participate equally, or at least we allow them a discretion at the same age? So do men and women get right to vote at different age? No. Do you get university admission at different age? No. Is it that men need to pass class 12th when they turn 25 and women need to pass 12th when they're 16 or 15? So similarly, why should there be any difference or discrimination on the basis of age with respect to age of consent with respect to marriage? The early age of marriage and consequent early pregnancies often have impact on nutritional level of mothers as well as kids, and therefore affecting overall health and mental well-being. It also has an impact on infant mortality rate as well as maternal mortality rate. And eventually it will also affect women's right to education. Why? Early pregnancy means early motherhood, and therefore most of the time you will be cut off from formal education. Dheeraj has a question. Please give me some idea how to crack CLAT. I can give you many, but this is not the right forum. We will conduct separate strategy sessions and master classes for all IMS students. Okay, so kindly note down Jaya Jaitley Committee. The Ministry for Women and Child Development had set up a task force in 2020 to look into this matter. They wanted to find out correlation between the age of marriage with issues of women's nutrition, prevalence of anemia, infant mortality rate, maternal mortality rate, and other social indices. Committee was headed by former Samta Party President Jaya Jaitley, who had also on board Niti Aayog member Dr. V.K. Paul and secretaries of several ministries. Committee was to look into the feasibility of increasing the age of marriage and its impact on women and child health. They also wanted to find out how to increase access to education for women. Committee was also supposed to recommend timeline by which government could roll out the implementation of the policy and what other amendments would be required in the existing laws in order for this to happen. Well, committee recommended that age of marriage for women must be increased to 21, which was adopted by the current regime and therefore this new law. Committee's recommendation was based on a vast feedback that they assembled from people from all age group, from different diverse social backgrounds. As per their own claims, they received feedback from youngsters from 16 different universities across country. 15 plus NGOs were also engaged in same task of getting feedback from different groups from far-flung areas and marginalized communities. Committee members have said that feedback has been taken from youth belonging to all religions as well as from rural as well as urban areas equally. So, till now, in India, situation was that we were allowed to vote when we turned 18, but we were not allowed to get married. So, concluding, I can say that you need more experience to handle wife than you need to handle a country. Well, next news item is Article 20, Kerala Medical Legal Society and another versus Government of Kerala. Why is this one important? Because in this, High Court of Kerala has expanded the scope of Article 21. What is Article 21? Right to life. Now, court declared that Article 21, that is your right to life, applies even after your death, till your body is cremated or buried. Well, quoting the judge, he says, the right to dignity and fair treatment is not only available to a living man, but also to his dead body. A decent burial of a dead body of a human being immediately after the death, if intended by the kith and kin of the person, is far more important than certain legal formalities to be conducted if it is an unnatural death. The obligation of the state to do the needful is in such a situation is paramount. So, court has expanded the scope of Article 21. Can someone try to connect right to be cremated to right to life? How are these two connected? Let me just go through some of the comments in the comment section. Welcome, Abigail. Okay. Chaliye. Article 21 says no person shall be deprived of his life or personal liberty except according to procedure established by law. Article 21 nowhere defines what kind of life are we entitled to. Later on, many Supreme Court benches in different cases have elaborated the meaning of life as per Article 21. While doing so, they expanded the scope of Article 21. For example, right to life also includes right to meaningful life. Right to life also includes right to have a dignified life. Expanding it further, in Puthuswamy judgment, Supreme Court couple of years back declared that right to life, which is a meaningful life, which is right to have dignified life, also includes right to privacy. So all these rights were nowhere mentioned in the Constitution, but through judicial interpretation, judges have expanded the ambit of Article 21 for us. Well, so judge noted in this particular case that Article 21 of the Constitution applies to a living person and will continue to do so until their body is cremated. Let me give you brief facts of this particular case. In Kerala, autopsies on dead bodies were being conducted only during daylight hours. So, सिर्फ दिन में autopsy होता है. Later on, government started a pilot project. What was the pilot project? At few medical colleges, including one in Thiruvananthapuram, Alappuzha, Kottayam, Thrissur and Kozhikode, they started allowing autopsies at night time. So 24-hour autopsy was made possible. Kerala Medical Legal Society has filed this lawsuit. Why? Because they are challenging the government order. Government has passed this order without providing adequate facilities to these medical colleges. So just imagine, what if there is no proper power supply? Andhere mein somebody is trying to do autopsy on your relative's dead body. That would be gross disrespect. Anyways, so autopsies were not performed after 5 p.m. until this order was passed. After this order, some colleges started doing it, some places started doing it. In this present petition, petitioner wanted court to direct the government to make it workable. Right now, in the current situation, government order was unworkable for many reasons. For example, shortage of electricity supply in certain areas. For example, lack of proper facilities or staff. Staff is also not available 24/7. And thus, Article 21 was interpreted in this particular way. Well, another important case is a court order to give security to gay couple facing opposition from families. In September 2018, Supreme Court ruled that sex between consenting adults was not an offence. The court struck down Section 377 of the Indian Penal Code and also declared that it had become a weapon for harassment of the LGBT community. Can someone tell me which landmark judgment decriminalized homosexual behavior in a country? So, name the landmark judgment through which Supreme Court decriminalized homosexuality. Okay. Satesh, that's correct answer. Correct answer is Navtej Kaur Johar. So, Navtej Kaur Johar judgment legalized, let's say I won't say legalized, decriminalized homosexuality in our country. So, in this case, a gay couple in Uttarakhand, Udham Singh Nagar, approached Uttarakhand High Court for protection to get police security. Why? Because the family members were against this relationship and they wanted to live together. The High Court bench of Chief Justice R.S. Chauhan and Justice N.S. Dhanik ordered the district SSP to provide police protection to the couple. Notices were also issued to both of their families. The court also ruled that any discrimination on the basis of sexual orientation violates fundamental rights. Well, this particular case that we are discussing is not important, but the issue is very important. So, homosexuality right now, though it has been decriminalized, but it is not legalized per se. Confusing, isn't it? Well, we have Hindu Marriage Act, we have Christian Marriage Act, Parsi Marriage Act, even Special Marriage Act. But all these statutes require that in order to get married, couple cannot be of same sex. So, for example, the entire language of Hindu Marriage Act 1955, though it nowhere specifically mentions that you need to have one man and one woman, it simply says you need to have two Hindus, but most of the provisions refer to the prospective couple as he and she. So thereby, homosexuality, though decriminalized, is not legalized. There is no Homosexual Marriage Act, so they do not have rights related to marriages. Okay, Jharkhand High Court, next news item is another High Court deciding to live stream their proceedings on YouTube. So YouTube is getting more and more important now. Jharkhand High Court recently decided to live stream its proceedings on YouTube on virtual dates of hearing. I would recommend all of you, if your preparation is going well and you can spare some time to go to these channels and check out live streaming of various case proceedings that are going on. So Jharkhand is not the only High Court. There are like 5 others. Viewers can watch live streaming by clicking on the live window in the menu bar of website of High Court of Jharkhand. It may be noted that the link available will take you to YouTube channel of the High Court wherein one can watch the live court proceedings. The live proceeding will be streamed only on virtual dates of hearing. So Jharkhand High Court became the 6th High Court in the country to commence live streaming. So you should note down that Gujarat, Karnataka, Madhya Pradesh, Odisha and very recently Patna High Court also decided to commence live streaming of court proceeding on YouTube. Patna was the 5th one to do so and Jharkhand is the 6th High Court. Okay, this initiative is started with the vision to enhance accessibility and transparency. Quoting Justice Oka, I personally feel live streaming should be there in limited form and selected cases. Let us have transparency. Nothing wrong with transparency. If parliamentary proceedings are live streamed, why not court proceedings? Of course, with all the constraints. I would like to second Justice Oka in his opinion here. Parliamentary proceedings are way more risky than judicial proceeding. You might remember those visuals in which our parliamentarians were caught blowing fists at each other. That means people have been getting into brawls all the time. They have been creating a lot of ruckus and nuisance and shaming the nation. Well, another controversial news item was Dilip Gatubhai Roat versus State of Gujarat. Question was, can you stop people from eating what they want? So Ahmedabad Municipal Corporation started confiscating carts of street vendors who were selling non-vegetarian food in certain areas of Ahmedabad. Gujarat High Court came down heavily on AMC. Why? Because this sort of action cannot be justified. Justice Brain Vaishnav was hearing the plea filed by 20 plus street vendors of Ahmedabad, challenging the non-implementation of street vendors under Protection of Livelihood and Regulation of Street Vending Act 2014. Yes, you heard that right. We have a special statute legislation which protects the rights of street vendors. Most of the street vendors whose carts were confiscated were selling eggs or items cooked from egg, and some were selling chicken and mutton. Well, petitioners' counsel argued that vendors' carts were seized only because they were selling non-veg item and there was no official order empowering the AMC officials to do so. Standing counsel for AMC submitted that the reason for removal was encroachment on the road. So we were confiscating to remove encroachment, and we were not singling out people who were selling non-vegetarian food items. But if you just look at data, it shows us that all the people whose cart got confiscated were selling non-veg items. So this is a very unusual coincidence in a city like Ahmedabad, where you won't find many non-veg vendors. Well, so to this, the judge commented that anti-encroachment drive was being used as a guise to target vendors of non-vegetarian food. It was also observed, how can you decide what people should eat? Suddenly, because someone in power thinks that this is what they want to do, tomorrow you will decide what I should eat outside my house. Tomorrow they will tell me that I should not consume sugarcane juice because it might cause diabetes, or coffee is bad for my health. Obiter dicta in this judgment stated, you cannot stop people from eating non-veg if you don't like it. Okay, very important news item, India's judges to population ratio. A question was posed by Member of Parliament recently seeking Law Minister's response on the judges to population ratio in the Lok Sabha. Union Law Minister Kiren Rijiju informed the Lok Sabha that currently we have 21.03 judges per million population. Guys, tell me, is it enough or do we need more? Or are they more than enough and we need to reduce number of judges? Yes, Satish, that's right. Okay. Of course, more. So, in the words of learned counsel Sunny Deol, तारीख पे तारीख मिली जज साहब, इंसाफ नहीं मिला. The reason being that there is a pendency of so many cases. So, backlog is so huge that the current strength cannot finish off all these cases even if their entire lifetime. Well, Department of Justice in the Ministry of Law uses the population count as per 2011 census. That is the data available. And the available information regarding sanction strength of judges in Supreme Court, High Court, District and Subordinate Courts. So, sorry, I hope you haven't seen it, so I will ask a question. Tell me then, what should be the ideal judges, what should be the ideal number of judges per million population in your opinion? So, if 21 is less, what do you think is optimum number? Sharvey says we need more judges to solve cases quicker. Well, it also depends on the judge. It is not necessary that if you increase number of people, that will decrease the backlog. You also need to make them more efficient, and that is what the focus is on right now. So rather than blindly increasing number of people, first we need to analyze, do we actually need that many people? Bhuvan says we need 100 at least. Satya says maybe 50. Ira says we already have enough. Okay. Well, there are two opposing views on this, and both views were expressed by the Law Commission of India. The first view was expressed in the 120th report, which was titled as Manpower Planning in Judiciary, a Blueprint. They recommended a ratio of 50 judges per million population. So congrats Satish, you got it right. But a more recent one, that is 245th report, says that judge to population ratio is not the best way to assess inadequacy of the judges. A better way would be rate of disposal method to calculate the number of additional judges required to clear the backlog of cases, as well as to ensure that new backlog is not created. A more pragmatic and useful way of finding out that right number of judges required in a country. Okay, RS is around 40. So 50 as per the 120th Law Commission report. But now we have changed the method. Now we say, let's find out rate of disposal. And you might be surprised to know that at lower judiciary, judges generally get a target. That means they have to dispose of certain number of cases of a certain type in a year. So they have yearly targets, they have quarterly targets. So they are also under pressure. Some of my friends who are working as judges right now, most of the time they crib about undue pressure which they get from the High Court, and that they are required to write a lot of stuff every day. On an average, you are writing 50 pages per day, which is torturous for many. Okay. The Indian Federation of App-Based Transport Workers, IFAT versus Union of India. This case relates to gig workers. Now, who are gig workers? People who are not in permanent employment. For example, your delivery guys. So, Supreme Court recently issued notice in a writ petition seeking social security rights for gig workers employed on online food delivery, courier and text aggregator applications like Ola, Uber, Zomato, Swiggy. Ola's as well as Uber's official stand is this, that these people are not our employees. We are just connecting drivers with people who want to travel. So we are just a platform, we are just aggregators. So we are not completely responsible for what they do. The counsel appearing for petitioners submitted that the drivers or delivery workers are actually workmen in the classical sense of the word. Why? Because all the terms and conditions that they need to follow are similar to what permanent employees or workers on payroll would have to follow. If you watch previous episodes of Weekly Law Scoop, in the second episode we did cover a case from UK where Uber workers approached the British court in order to claim their status as workmen rather than gig workers. And it was held by the British court that Uber drivers are not gig workers, rather they are employees. And hence Uber would be responsible for their behavior as well as for their well-being. Supreme Court of UK analyzed the contract between Uber and employees, and that it says that it is evident that the relationship is of that employer and employee. Bench then pointed out that new legislation, in this current case it was pointed out that the new Social Security Code of 2020 passed by the Parliament last year has a chapter dedicated to welfare of gig workers. Well, petitioners have also sought that declaring gig workers and app-based workers as unorganized workers and wage workers within the meaning of Section 2M and Section 2N of Unorganized Workers Social Welfare Security Act of 2008. So we are still waiting for the final verdict on this particular matter. When it comes, it will become very important. NDPA Amendment Act, this one is not that important. It's just that government has recently passed a new amendment. It is called Narcotic Drugs and Psychotropic Substances Amendment Bill of 2021, which was passed. And there was a typographical error, rather I won't say typographical, there was a drafting error in this new legislation. 21 amendment contains a legislative declaration about what one section refers to. It says Section 2 clause 8A corresponds to clause 8B in Section 27. since 2014 when the provision was first brought in. Now it is too technical, आपके लिए ज़्यादा काम का भी नहीं है, but still I will go through it so that if some of you want to note it down, they can. So 2021 amendment says that section 2 clause 8a corresponds to clause 7b in section 27. That means these two are interrelated. Section 27A of NDPA Act 85 prescribes punishment for financing illicit traffic and harboring offenders. In 2014, many amendments were made in NDPA Act to allow better medical access to narcotic drugs. So, Section 8A, the amendment defined essential drugs under Section 9. It allowed manufacture, possession, transport, import, interstate, export, interstate, sale, purchase, consumption, blah blah of narcotic drugs. So, that means earlier something was punishable, later on because we made changes, numbering of some of the provisions changed, and this this connection got lost. So it's just a typographical error, or you can say drafting error, which needs to be rectified. It was rightly taken up by the Tripura High Court while hearing a reference made by District Court. They flagged it and they referred it to the Supreme Court of India, and they have sent a copy to the government. Now government will rectify it and it will be soon changed back to its original form. Well, State of Maharashtra versus Ajay Marathe. This is important. Supreme Court has allowed Maharashtra to hold bullock cart races in states till the pendency of the case before the constitutional bench of the Supreme Court. The races will be held in several parts of the state, especially Pune and the western Maharashtra region, where the 400-year-old tradition was prevalent. Supreme Court observed that the validity of amended provisions of Prevention of Cruelty to Animals Act 1960 and the rules framed by Maharashtra would operate during the pendency of the petition. So in India, in last couple of years, voices for animal rights were growing louder, and many customs, rather many such events were being outlawed by the government one by one. For example, Jallikattu became a big issue in Tamil Nadu. So a couple of years back, government decided to prohibit Jallikattu, which is again a bullock cart related festivity, stating that it amounts to animal cruelty. It became a mass movement of people. People thought that this is an attack on their tradition, and under public pressure, central government decided to bring in an ordinance. State government brought in an ordinance and central government approved it, supported it. So if Tamils are allowed to perform Jallikattu, why Maharashtrians shouldn't be allowed to have their own similar rituals or similar customs? And therefore, Supreme Court observed one country, one race, we need to have uniformity and there has to be one rule. If the races are going on in other states, why should it not be allowed in Maharashtra? So it's a temporary thing. Once government makes up its mind ki karna kya hai, might be either we will ban all such events or we will allow all these events. Okay, so let's move on to quiz. Today we are not going to Menti. I would want you people to quickly answer in the comment section. I have just set up a new studio in a new city, so please bear with me if the audio is not that great. We are continuously improving on that part, and before your next episode, everything will be in line. Chaliye. First question on your screen. What is the full form of NFHS? We discussed it today. What is the full form of NFHS? Is it National Family Health Survey, National Family Heritage Survey, National Female Health Survey, or National Female Help Survey? Satej is the first one to answer, then Ira, then Arya, then Vardhan, Sharvari, Harshada. Okay. Prachi. Everybody is saying A because it's an easy question. Correct answer is option A. Answer this. Article 21 applies only to living person. Answer based on new realities. Answer based on new realities. That means what is the current understanding of the judiciary? Answer is false. Now we know that it applies to your dead body too. That means till you are cremated or buried, your right to life will still be with you. Though your life won't be, your right to life would be. Okay. Supreme Court permitted marriage between same-sex couples who are adults by striking down Section 377 of the IPC. The statement is true or false? Question number 3. Let's see. Vinayak, Harshada, Ira, Arya, Prachi, Purvi, Bhuvan. So true, false, true, false. Okay, some of you were not paying attention when we discussed it. In India, homosexuality has been decriminalized. That means there is no punishment for homosexual behavior. But still, they do not have right to get married. So there is no provision of alimony, there is no provision of maintenance. Neither the customary laws have been amended, nor the Special Marriage Act. So nowhere we have explicit arrangement, or we have clearly put in the statute book to give them legal right. So as of now, yes, it is not a punishable behavior, but it is also not a valid form of marriage. Let's move on. Which is the 5th High Court to commence live streaming of court proceedings on YouTube? Your options are Patna, Gujarat, Jharkhand, Odisha. Let's see how many of you can get it right. Okay, Shraddha will go with A, Satej with C, Vardhan with C, Ira with C, Harshada with A, Bhuvan with A, Arya with A. Satej ने आंसर चेंज किया, विनायक ने भी चेंज किया. Well guys, correct answer is option A. So Patna is the 5th High Court to start live streaming. Which was the first state to start live streaming of court proceeding? First state to start live streaming. Bonus question, which was the first state to start live streaming of court proceedings on YouTube? Yes, correct answer is Gujarat, and Jharkhand that we discussed today became the 6th state to do so. Chaliye, so street vendors are protected under. Your options are Protection of Life and Regulation of Street Vendors Act 2014, Protection of Livelihood and Regulation of Street Vendors Act 2014, Protection of Livelihood and Regulation of Street Vending Act 2014, Protection of Life and Regulation of Street Vending Act 2014. काफी मिलते जुलते ऑप्शन. लेट्स सी. B, C, B. Okay. Sharvi will go with C, Arya with B, Ira with B, Satej with B, Harshada C, Devanshi will go with C, Prachi will go with B, Vinayak B. Okay. Well guys, correct answer for this one is option C, Protection of Livelihood, not life, Protection of Livelihood and Regulation of Street Vending Act of 2014. Chaliye. Who is the Union Law Minister? Your options are Smriti Irani, Ravi Shankar Prasad, Amit Shah or Kiren Rijiju. Smriti Irani, Ravi Shankar Prasad, Amit Shah, Kiren Rijiju. Bonus points for telling his law school. Where is he from? Correct answer is option D. Everybody knows that. Kiren Rijiju. So Kiren Rijiju completed his LLB from which college or university? Okay. Correct answer is Delhi University, Faculty of Law. Okay. Which legislation has a chapter dedicated for the welfare of gig workers? Which legislation has a chapter dedicated for the welfare of gig workers? Unorganized Workers Code 2020, Gig Workers Code 2020, Labour Act, Social Security Code 2020. Everybody got it right this time. Correct answer is option D. It is Social Security Code of 2020. Currently, there are dash number of judges per million population. So, what is the current judges to population ratio? How many judges per million population? 22.03, 22.02, 21.03, 21.02. C. Correct answer is option C. It is 21.03. Okay. Prevention of Cruelty to Animals Act was enacted in the year. We didn't discuss that this one in detail, but some of you might have seen. So 1950, 1970, 1960 or 1990. The Prevention of Cruelty to Animals Act was enacted in the year. Option C. Harshada will go with C. Arya will also go with C. Purvi will pick C. Correct answer is option C, in 1960s. Okay, I will give you a bonus question which you can answer once this live stream ends. Name the case in which Uber drivers were declared to be workers of Uber and not just gig workers. Okay. Thank you so much for attending the live stream. I hope you guys liked it. We'll go back to our original format. We will start using Menti from next episode onwards. If you have any suggestion, you can text me. All of you have my number. If you want me to include any particular news item in the next episode, please make sure that you leave a comment after this live stream ends so I can come back to the video. I can check out what all news item you want me to cover and we will include that in upcoming sessions. Thank you so much for watching. Don't forget to like, share and subscribe. याद रखिए बांटने से नॉलेज बढ़ता है और साथ में सब्सक्राइबर्स भी. So keep sharing. Good luck. Goodbye. Have a nice day.